Hello, good afternoon, and welcome to this NQA webinar. Does ISO 27001 cover the requirements of the GDPR? Just a few housekeeping bits before we get going. If everyone can hear me okay, if someone could just pop a little note in the question box at the side there, so I know I'm not just speaking to myself. Yes, brilliant. Thank you, Adrian. Thanks so much for that. Okay, we'll get going then. So this is just a bit of an overview of NQA, of who we are, what we do. As you can see there, we've been in business for over 30 years now, and we operate in over 32 countries. And we hand out around 36,000 certificates globally. These are just some of the clients that we work with, and our price promise. We don't charge travel expenses. It's an all-in process. So why we're here today then? Well, we're here today to look at 27001 and how it relates to GDPR. So the kind of things we're going to look at is why and what is a GDPR? It's been in place now since the 25th of May, but what is it? How is data going to be processed under the GDPR? We'll look at data breaches as well, and we'll talk about how data breaches are looked at within the GDPR and also within 27001. And then we'll look at how 27001 can help. And we'll also do a bit of mapping across from 27001 to GDPR. Now, one thing we have to stress is, while this is a webinar regarding 27001 and GDPR, the 27001 and gaining certifications to 27001 will go a long way to helping you gain compliance under GDPR, but it won't go the full way. Don't think that by gaining certifications to 27001 alone will see you fully compliant to GDPR. So a bit of background then. In today's ever-evolving digital environment, the protection of personal data has become more critical than ever. As data breaches occur with greater frequency, the cybersecurity standards which were put in place 20 years ago are no longer enough to protect the information of businesses and customers that interact online. The larger a database, the graver the consequences of a breach for both parties. The GDPR is intended to solve these security issues that have emerged over the past 2 decades since the development of cloud technology and also its impact on data security. So what is it? The GDPR, or the General Data Protection Regulations, were developed by the European Union over a 4-year period to serve as a legislative solution to issues regarding data protection in the current day. Previously, the laws regarding data protection in the UK were based on the Data Protection Act of 1998, and this in itself was an update of the 1995 EU Data Protection Directive, which itself was designed to handle security issues which were understood by lawmakers and programming experts in the years leading up to the millennium. As we can see, the new legislation took effect at the 25th of May this year, and it will affect across Europe and affect businesses globally also. Now, the regulations are designed to protect customer data in a new digital environment. In an age where companies like Facebook and Google share the personal data of account holders in exchange for site access and features, the GDPR seeks to return more control of the situation back to the user, back to us. The other reason for the GDPR is to establish a clear-cut set of regulations under which businesses can operate in regards to the handling of customer data. Now, with these new rules, the boundaries would be easier to understand on both the corporate and also consumer end, which would make it easier for businesses to earn and hold the trust of customers. The law also offers more power to citizens in regards to what companies can do with their private data. Now, while the new law will be beneficial on all sides, the GDPR has been designed to protect consumers. Fears of advanced online hackers could be reduced, if not eliminated, by the new regulations. And with the new laws on data protection more clearly defined throughout the EU, the GDPR could potentially save the European business economy roughly, and this is an estimate, roughly been estimated to be £2.3 billion a year That saving in turn could be passed on to consumers. So who does the GDPR affect then? Well, there's two parties in the realm of data security that are directly impacted by the implementation of GDPR. These are the controllers and processors of digital information, and you will fall into one of those categories. Now, according to Article 4 of the GDPR, the roles are identified as stated on the screen there. So we've got controller and processor. So controller, according to Article 4, means the natural or legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and means of the processing of personal data. Processor, on the other hand, is the natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. So the controller decides what will be done with the data, and the processor processes it or handles it on behalf of the controller. And as I said, you will fall into one of these categories, or indeed both. So the organizations that determine the means of processing personal data, as we said, are controllers, regardless of whether they directly collect the data from data subjects. For example, a bank could be classed as a controller, collects the data of its clients when they open an account, but it is another organization, the processor, which stores, digitizes, and catalogs all the information produced on paper by the bank. These companies can be data centers or data management companies, for example. Now, both organizations, the controller and the processor, are responsible for handling the personal data of these customers. The data controller remains responsible for ensuring its processing complies with the GDPR, whether it processes it in-house or engages a data processor. It is the controller's responsibility to determine how it monitors and evaluates the processors. Data processors face direct legal obligations under GDPR in such areas as security and record keeping. Under the GDPR, controllers can only use processors providing sufficient guarantees to implement appropriate technical and organizational measures so that the processing meets the requirements of the GDPR and protection of the rights of the data subject. So, in brief, the controller must show due diligence when they are picking their processors, and the processors must show that they've used all the relevant controls, technical and organizational measures to keep that data secure. If processors breach their direct obligations, they can be fined by the supervisory authority and held jointly liable with the controller for the entirety of any damage to a data subject, unless they can prove they were not in any way responsible for the event. So who does the GDPR affect then, carrying this on? We're going to talk about transparency now. Now, according to Article 5 of the EU GDPR, the controller should be responsible for and be able to demonstrate compliance with the principles relating to processing of personal data. Now, these are lawfulness, fairness, and transparency, data minimization, accuracy, storage limitation, and integrity and confidentiality of personal data. Now, Article 28 from the EU GDPR states, where processing is to be carried out on behalf of a controller, the controller shall use only processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of the regs and ensure the protection of the rights of the data subject. And moving on, according to Article 83, fines shall be imposed regarding the degree of responsibility of the controller or processor, taking into account technical and organizational measures implemented by them. So this just reinforces what we've already discussed. Now, when the GDPR was implemented on May 25th of this year, controllers were required under law to process EU data for specific purposes with complete transparency. Once the purpose is completed and the controlling processor or the controlling processing entities have no lawful need for the data of a given user, the data must be deleted. Therefore, personal data will no longer be stored idly and indefinitely on servers that could be hacked at any time. Now, for the personal data of EU residents to be processed lawfully under the GDPR, at least one of the justifications mentioned above will have to apply. The law is designed to put the interest of online users above the entities that could be intent on exploiting or sharing personal data. So, as we can see there, the four lawful topics that can be considered for processing is the protection of an interest deemed essential to the life of an individual, for the prevention of fraud, for the processing of data within the interest of the public, or a compliance with a legal contract. Now, we're going to talk about consent, private data, and the right to be forgotten now. This has been quite a sticky subject for some people, especially when I've been going around and talking to different people. Now, for controllers to get the agreement of an individual, a person must give consent through a direct, confirmed action. The pre-existing standard of justification, which allows controllers to use data only with only passive acceptance on the part of the person, it doesn't suffice under GDPR. So therefore, consent cannot be gained through means that would only be understood by users who pass over the fine print of a given set of terms. Now, it's a controller's obligation to keep a record of the time, date, and means through which a person has given his or her consent. And they must respect the individual's wish to withdraw from this at any time. Now, any business, charity, or government agency that doesn't currently conform to these new regs will have to bring their protocols into compliance. Now, for many companies, the implementation of best practice standards, such as 27001, has made this transaction a lot easier. Data storage systems or backups or rollback systems, they have to be developed so as to protect data and maintain its privacy. Now, organizations may need to complete a legacy data audit to ensure that any personal data held by a processor or controller does so in line with the GDPR. Then this is going to enable organizations to identify where consent was granted correctly and also delete records where consent was not or cannot be obtained. Now, there's different categories of personal data. And the category that constitutes private data within the EU has become a whole lot broader under the GDPR. Now, in response to the type of information that companies now gather from individuals, information about a user's computer and location, as indicated by an IP address, will now be considered private data. Other information, such as the financial, psychological, or ethnic history of an individual, would also be defined as personal information. Anything that can be used to identify an individual would qualify. Now, personal data is defined as anything that can identify a natural person, a living human, either directly or indirectly, and can be anything such as a name, photo, email address, which includes work email, bank details, medical information, biometric and genetic data, or even, as we said, a computer IP address. Now, a person can request to see his or her private data at reasonable intervals as defined by the GDPR. Under the new law, controllers are obligated to respond to a user's request within 30 days. The new regulations also require controllers and processors to maintain policies of transparency regarding the means through which data is gathered, used, and processed. The language used to explain these processes to people must be worded in simple, clear layman's terms and not be littered with confusing jargon. So basically, it can't read like a formal legal document. Each individual is entitled to access any private data held by a company. Furthermore, each individual has a right to know just how long his or her information will be stored, which parties will get to view it, and the reason for which the data is being used. Now, whenever possible, controllers will be encouraged to offer secure viewing access for any account holder who wishes to see his or her personal information as held in a company database. People will also be able to request that incorrect or incomplete data be corrected at any time. Now, a person can request that his or her data be deleted at any time for any reason under a clause of the GDPR known as the right to be forgotten. Now, if an individual feels that his or her data is no longer essential for the original purpose of its collection, such as when an address is collected to verify that a person meets the geographical requirements for taking part in a contest or survey, well, a request can be made to have the information removed from that database. Now, when a request to be forgotten has been made, the controller is obligated to inform Google and other data gathering organizations that all copies and links to said data must be deleted. The risk of having dormant personal information linked to a third-party marketeers will be greatly minimised under a new law. Now, organisations can only charge for these subject access requests if they are instituted without sufficient grounds and serving only to cause annoyance to the organisations. So if, for example, someone is submitting request after request after request after request with no valid reasons, then a small charge may be applied. The GDPR actually allows you to exceptionally charge an admin fee for unfounded excesses or repetitive requests. Organizations are also able to refuse to respond to requests, but you have to be able to demonstrate the unfounded, excessive, or repetitive nature of the request. Personal data can be stored for longer periods under GDPR, provided that the personal data is processed solely for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes in accordance with Article 89(1). This personal data must be stored by the appropriate technical and organizational measures in order to safeguard the data subject's rights and freedom. The GDPR requires that data should be kept for no longer than is necessary for the purposes for which the personal data are processed. Now, organizations have to identify what personal data they process and the reason for processing to determine retention periods that are appropriate for each type of record. So we're going to talk about breaches now, and we'll look at how breaches are controlled under GDPR, but we've also got some examples of recent breaches as well. So any organization that collects the private data of users is required to report news of a data breach to a protection authority. Now this news, it has to be reported within 72 hours of when the breach first becomes known to the organization. Now, obviously in the UK, the Information Commissioner's Office, the ICO, serves as the authority on such matters. Failure to notify the Data Protection Authority, the ICO, in the UK within 72 hours could result in a fine of as much as 2% of a company's annual revenue, global annual revenue, or a fine of £10 million, whichever happens to be a larger amount. Now, if you compare this to previous ICO fines under the Data Protection Act, which only went as high as £500,000, the new penalties are far stricter. Now, the 72-hour deadline to report a breach, it will not always give an organisation enough time to learn the full nature of a particular offence. However, it should provide sufficient time to gather adequate information for the authority about the kind of data that will be affected by said breach. And just as importantly, an organisation should be able to give a rough estimate of the number of people that will be impacted by the breach. This way, potentially affected parties will have more time to react themselves. Now, you only have to notify the relevant supervisory authority of a breach where it is likely to result in a risk to the rights and freedoms of individuals. If unaddressed, such a breach is likely to have a significant detrimental effect on individuals. So, for example, resulting in discrimination, damaged reputation, financial loss, loss of confidentiality, or any other significant economic or social disadvantage. Now, this has to be assessed on a case-by-case basis. For example, you will need to notify the relevant authority about a loss of customer details where a breach leaves individuals open to identity theft. But on the other hand, the loss or inappropriate alteration of a staff telephone list, for example, would not normally meet this threshold. So we're going to look at some examples of breaches now. And if an organisation fails to abide by the core principles of the GDPR, such as gaining consent, respecting the rights and obeying requests of individuals, the organisation could face fines twice as much as those imposed for failing to report a data breach. So under the GDPR, the fine for failing to follow the new law could be almost double that of failing to report it within a breach within 72 hours, which is 4% of a company's global revenue, or £20 million, again, whichever happens to be a larger amount. Now, a lot of people ask what happens at Brexit, with this being an EU legislation, what happens when we leave the EU? Will it still count? Well, until the UK actually withdraws from the EU, companies based in England, Scotland and Wales still have to be in full compliance with the new laws. Now, British citizens, meanwhile, will be protected under the GDPR until Brexit takes effect. Now, once the UK has completed its exit from the EU, British companies will still be required to follow the new regulations when handling the private data of EU citizens. The GDPR has direct effect across all EU member states, and this means organisations will still have to comply with regulation, and we will still have to look to the GDPR for most legal obligations. However, the GDPR gives member states limited opportunities to make provisions for how it applies in their country. Now, one element of the Data Protection Act 2018 is the details of these. It's therefore important that the GDPR and the Data Protection Act 2018 are read side by side. So now we're going to look at some breaches regarding data protection. And as you can see there, there's a list of current fines. So the first one is Gloucester Police were fined for revealing the identities of abuse victims in a bulk email. They were fined £80,000. The incident happened in December of 2016 now, so that was dealt with under the Data Protection Act, hence why it was only £80,000. Then we've got Yahoo, who after systemic failures put customer data at risk. They were fined £250,000. Again, that was in November 14, so not under GDPR. We move on to the Bible Society. They were fined £100,000 after security failings put supporters' personal data at risk. Again, under the DPA. And a more recent one, we've got Dixon's Car Phone there, who came to light recently, actually after the GDPR went live, but they were fined £400,000 because the incident was deemed to happen whilst under the Data Protection Act. So they kind of got off lightly, let's say. We've also got some more there. So we've got the University of Greenwich. They were fined £120,000 by the ICO for serious security breach of 20,000 people, including students and staff. BT had been fined £77,000 after it sent nearly 5 million nuisance emails to customers. Again, dealt with under the Data Protection Act. And lastly, the Independent Inquiry into Child Sexual Abuse were fined £200,000 for revealing the identities of abuse victims in a mass email. Now, all this information has come direct from the ICO's website. So at the time of compiling this webinar, this information was up to date. And looking at the ICO website, currently they're standing at 957 reported data security incidents in their Q4, so the last part of their financial year. Now that was up 17% on the fine on the previous quarter. Now the big areas for an increase of data security incidents were the charitable organisations. They had a 69% increase in data security incidents. Now this is since GDPR. Education rose by 32% as well. Now, again, what the ICO website does state is that people are a lot more aware of data security incidents now and a lot more open to reporting things, which could explain the rise in increased levels. So, how can we comply? How can we comply with GDPR? Well, to ensure that your organisation complies with GDPR, you'll need to take stock of your existing processes regarding data. So, conducting internal audits, as well as bringing in outside auditors to review your procedures, can help you get a clear picture of where you are and where you need to be. You might also need to work with a cybersecurity expert, for example, if you need to improve your understanding of some technological issues. Make sure you can identify all the personal data you have. We spoke before about doing legacy audits of all your data processing facilities. Document where it all is, who it belongs to, with whom you share it, and other relevant information. GDPR requires you to record all data processing activities, so make documentation a priority. If you don't have sufficient knowledge about all your data, conduct an audit, as we've said. Find out where that information is. Don't forget, personal data can come from customers, employees, volunteers, and many, many other groups. Next, you should have all by now set up new procedures that comply with GDPR in some aspects. Now, this process could take a substantial amount of time and effort depending on the state of your existing data management policies. These tasks may include, but are not limited to, the following: updating privacy notices and consent management. You may need to adjust your privacy notices to comply with GDPR. You likely already use such notices, but if they do not contain all information the new rules require, you'll need to update them. GDPR requires that they inform the user about how long you keep the data and the reason for which you are processing it. Again, if like me, you've come the 25th of May, you were inundated with emails regarding, we're updating our privacy policy, please read and sign. It seems to have died down a bit now. I don't know about yourselves, but that's one thing. It does need to be updated, and you can understand why you've had all those emails now. GDPR regulation, it makes changes to how organizations get consent to process data, and it lays out more stringent requirements and emphasizes that requests for consent must be clear and easy to understand. Data subjects, so the people whose data you process, they've got certain rights under GDPR law and can make particular data-related requests with which organizations must comply. Now, you might already have some of these processes in place. If you do, you should make sure they all meet GDPR requirements. If they don't, you'll have to set up procedures for how to handle them or tweak the procedures you've already got in place. Now, the new rules give users various rights of access, and they specify information that you must provide people with when you process their data. Data subjects can also make various requests of data controllers under new regs. Now, upon request from a data subject, the controller must also provide confirmation of whether their data has been processed. So the subject can also request that you correct any inaccurate personal data, erase their data, and give them a copy of their data. This last right, unlike the right to be forgotten, is known as data portability, which allows them to transfer that data from one to another controller. GDPR includes various conditions to protect against data breaches and also lays out reporting requirements for if a data breach occurs. You should have a system in place to determine if data was compromised, which should include identifying vulnerabilities, monitoring access, and detecting threats. And let's remember some of these things because we'll come back to these issues when we look at the 27001 requirements. You also need to put in place a plan for informing the regulatory body as well as any affected EU citizens if a breach occurs, as we mentioned when we talked about breaches. You must send out this notification within 72 hours of the event, which must include information such as the likely consequences of the incident and the measures taken to address it. GDPR requires all data processing entities to track and record all our data processing activities. So documentation is crucial for demonstrating compliance to record data processing activities. Another critical step of preparing your systems is assigning responsibilities for data management and other GDPR related tasks to ensure that they consistently get the necessary amount of attention. So for organizations whose core business involves data processing or handle sensitive information, assigning these responsibilities will be a formal process. GDPR directs them to appoint an official data protection officer or DPO who has expertise related to data privacy and security. Now, from my experience, a lot of companies have appointed a DPO who don't necessarily have to, but they've just appointed a DPO to be the focal point for all data security matters, and there's nothing wrong with that at all. Now, once you have your data protection processes in place, it's time to implement them. GDPR compliance, however, it's not something you can just set and forget. You'll have to monitor your data systems and perform regular audits to ensure everything is working correctly and identify areas for improvement. So you'll have to respond to requests from data subjects, control and monitor who has access to data and how it is processed, watch for cybersecurity vulnerabilities and threats, react to any data breaches or other security issues, and document all data processing and compliance activities. Now, this is not any, for those of you who've got management systems in place, it's nothing new. We've seen all this before, and we've seen it all in the PDCA, the Plan, Do, Check, Act cycle. So as we've just seen there, we've got plan, assess and audit, do, identify, check, review your processes and enact, implement those changes if needed. So for those of you, as we said, you've got management systems in place, how does that relate to 27001? Well, organizations around the world have studied the GDPR and they're likely aware that the regulations are an encouragement to adopt best practice schemes. Now, ISO 27001 is an information security standard which helps companies come into compliance with international best practice models. The standard covers 3 key components of data security: people, processes, and technology. Now, when steps are taken to safeguard data with these 3 components in mind, businesses are better equipped to protect information, mitigate risks, and rectify procedures that are deemed ineffective. And as such, a growing consensus has emerged in the corporate sector that deems ISO 27001 to be the gold standard in best practice schemes. By putting the ISO 27001 standard into effect, an organization activates an information security management system, or ISMS, that works within the business culture of the company in question. Now, the standard is regularly updated and enhanced, and these ongoing improvements allow the ISMS to stay abreast of changes both within and outside the company, all the while spotting and eliminating new risks. Now, if you already achieved certification to ISO 27001, you may have noticed the similarities between that standard and also the GDPR. Now, it's designed to support the confidentiality, integrity, and availability of your information and help you maintain legal compliance. It also helps you to protect your data from cybercrimes, misuse, fire, theft, and other threats. Now, having a certified ISMS in place will give your customers more confidence in your company, as well as improve your relationships with other stakeholders and also help you mitigate risks. So the 3 things we've got up there then: confidentiality. Now, a common example of confidentiality would be an online transaction conducted over secure methods, such as the use of encryption, whereby information is protected via secure certificates such as HTTPS. As for integrity, an example would be the trustworthiness of a customer financial account information, i.e. bank accounts, personal data, which is held by a bank for conducting daily operational transactions. And finally, availability. Now, this could pertain to a bank's customer-facing web service that hosts the online banking portal for which customers can access any time of day. And we've seen an example of availability with one of the main high street banks going offline for a number of days recently. So, how does this map across to the GDPR then? Well, if you think back to a few things we looked at, we'll discuss those now and how they relate to 27001. The first one being data encryption. Data encryption. Now, this is encouraged by 27001 as a primary method to reduce the possibility of risks. Now, in 27001, more than 100 controls are outlined for use, each of which can be implemented to lower the possibility of security risks. With each control based on the result of a previous risk assessment, any organization that utilizes the standard can pinpoint the at-risk assets and apply the necessary encryption. Confidentiality, integrity, and availability of data. We've just discussed that. Risk assessments. Now, according to ISO 27001, an organization must enact complete evaluations of all possible vulnerabilities that could impact the company's data and to leave no stone unturned in the effort to safeguard the privacy, accessibility, and integrity of that information. Now, at the same time, the standard discourages the use of overbearing security protocols that could hinder a company's ability to operate efficiently. Business continuity then. So in 27001, the fundamentals of continuity in business management are laid out, whereby controls are implemented to help a company keep vital information readily available in the event of a system interruption. These same protocols can assist a business in its quick recovery from what would otherwise be a lengthy and costly shutdown. With the standard in place, companies experience little, if any, downtime. Testing and assessment. An organization that gains 27001 certification receives assessments and audits of its ISMS by a third-party certification firm, such as ourselves, NQA. This ensures that the ISMS is compliant with the standard. Any company that implements the standard must keep its ISMS under constant review to ensure that it remains protected of private data. Compliance. Now, according to Control A18.1.1 of ISO 27001, which concerns the identification of applicable legislation and contractual requirements, an organisation must list all legislative, regulatory and contractual requirements. If an organisation is required to comply with GDPR, this must be listed as one of the regulatory requirements. Even without EU law, Control A18.1.4 leads organisations that utilise the standard through a process of enacting data protection. So, a lot of people ask, will ISO 27001 be updated to include the requirements of the GDPR? Well, no, because it doesn't need to, because it already does state that you should be in compliance with GDPR, in that you should, under the compliance clause of A18.1.1, you should identify all the relevant applicable legislation and detail how you show compliance to that. Moving on, breach notification. Yeah, we spent a lot of time on breach, and 27001 control measure A.16.1 ensures the efficient management of security incidents, which helps organisations come into compliance with the GDPR, under which authorities must be notified within 72 hours, as we said. Now, companies that have implemented the standard are faster to respond to such incidents, which makes compliance in this area a lot easier to meet. Finally, asset management. So this is addressed under ISO 27001 Control A8, which includes personal data as an information security asset. Organisations that implement the standard are given an understanding of which types of data are essential, as well as where such data must be stored and for how long. Now, Control A8 also covers the origin of personal data and the party that gets to access the data, all of which, as we spoke about, are requirements of GDPR. Now, of course, the requirements of ISO 27001 extend far beyond the principles as mentioned earlier. As an all-encompassing best practice standard, various other areas are also covered, such as methods that apply to staff training. Now, the standard has been implemented by countless organisations throughout the world. With the frequency and consequences of these data breaches, the standard has become an essential part of data security in a digital marketplace. Now, just to recap, as we said earlier at the start of the webinar, 27001 will go a long way helping you achieve compliance to areas under the GDPR, but it will not go the full way. So do not use 27001 to get you fully compliant with GDPR. It's a good stepping stone, but it shouldn't be used exclusively. Now, as I just touched on there, while there are some areas covered under the GDPR that are not controlled under the ISO 27001 standard, such as the right of a data subject to have his or her data moved or deleted. Now, the standard covers most of the requirements of new law by virtue of the fact that private data is recognised as an information security asset under 27001. As such, the standard and new regulations share like-minded views on data security. Essentially, any company that interacts with EU residents will need to reach compliance with GDPR. And because 27001 is considered far and wide as the most secure of all the best practice standards, it will likely prove to be the most applicable standard under the new regulations. Already, more and more companies are swiftly implementing the standard to assist with compliance with the new law. ISO 27001 is one of the most applicable standards for GDPR compliance. If the standard has already been implemented by a company, that company is already more than halfway compliant with new regulations. And no matter where in the world a company is based outside the EU, that company will still need to be in compliance with GDPR as long as it gathers the personal data or sells goods or services to EU residents. Now, this would apply to a company worldwide that collects money or information from people on the internet. Organisations with 27001 certification are likely to meet many of the appropriate technical and administrative security requirements of GDPR, but many may need to make some adjustments. Now, Article 42.1 of GDPR provides that all member states, supervisory authorities, the board and the commission are to encourage the establishment of data protection certification mechanisms for the purposes of demonstrating compliance with GDPR. So that's the part where we mentioned earlier that the GDPR actually encourages people to gain certifications to these best practice standards. Now, ISO 27001 has a broader scope than GDPR in that it applies to a company's critical data as well as the personal data. The ISO standard can be used to protect personal data as well as any other information. GDPR also covers several areas that 27001 doesn't know, such as the right to be forgotten, data portability, and the right to be informed about your personal data. 27001 doesn't explicitly address these rights, but an ISMS can support you in meeting these requirements. Because 27001 doesn't specifically include these rights, being certified to it doesn't necessarily ensure you're also GDPR compliant. It will certainly support you in your GDPR compliance goals and bring you closer to reaching them. Because the standard and regulations have some differences in what they cover, all 27001 certified companies impacted by GDPR should conduct a gap analysis. This assessment, which NQA can perform, will provide you information about where you are now and where you need to change. It identifies the gaps between your current systems and the ones you want to follow. Now that's it for the webinar. So this is where we've got a bit of time for some Q&A. If anyone's got any questions, you want to pop them in a box, but I'll try and answer them as best as I can. I see we've got one question there. Thanks for that. So do we need to mention extensively that we use GDPR like in our statement of purpose in ISMS? As I said, if you've got 27001 implemented in your company already, you within your legal register or where you've identified your applicable legislation, as an auditor, I would definitely expect to see GDPR in there. So you don't have to necessarily mention GDPR in your statement of purpose, but you have to identify it as an applicable legislation under that clause A18.1.1. I've only got the one question for now. Have we got any more, or was everyone happy with that? If you do think of any more questions in the meantime, please feel free to email the team at the web address on screen now, and we'll get back to you as soon as we can. If we do get a lot of questions, we'll put out another frequently asked questions blog. If you have got some questions that you don't want to kind of put on the screen just now, feel free to go to our website at nqa.com. If you go into the resources page for information security, you'll find the frequently asked questions from previous blogs, and that may answer some of the questions you have. But in the meantime, thanks for listening, and we'll see you again soon.